Stage is yours.
Well, thank you very much, and thanks for the kind introduction. Thanks for your time so late in the evening. Yeah, the colleagues from Ewpg, is that correct, already told us something about the Ewpg. And now we're going to delve a bit deeper into that and concentrate on service providers, the crypto registrar, and the licenses obligations. So that's quite a technical topic. I'll try to keep it as down to earth as possible. And I think we can discuss questions afterwards. So first discussing the Crypto Securities Registrar in the context of the new law and what consistencies the different parts of the law do have. And then it's regulated as a financial services institution. So we first look at general requirements that apply to financial services institutions and then to specific requirements under the Ewpg that you of course also have to meet. Right, so there's the Ewpg itself. And then there's the German Banking Act, and the actual license requirement has been implemented in the Banking Act, as we will see in a minute. We also have the Ordinance on Requirements for Electronic Securities Registries, which is basically the main source of law for the requirement in detail that the registrar has to meet. And then there's the Ordinance on Crypto Fund Units that has already been mentioned too. I want to talk about this any further here, but just to mention it. So the license requirements for financial services institutions is included in 32 Banking Act. And there we have the new definition of financial service, the operation of a crypto securities register under paragraph 16 of the Ewpg. When we look in there, we already found out that we have two different kind of electronic securities registers, the central register that can only be operated by a CSD or a custody institution. And we have the crypto securities register, das Krypto-Wertpapierregister, that you can operate with a financial services institution license. So what is a crypto securities register? We have this definition here, which is kind of technical and a bit complicated. Maintained on a tamper-proof system of record, in which data is locked in time sequence, stored in a manner that is protected against unauthorized deletion and modification. And this system of record must be a decentralized combination in which the rights of control are distributed between the entities operating the system according to a predetermined pattern. So what does this mean? This sounds very complicated, and you ask yourself the question, why don't they just say this could be a DLT or a public blockchain? And they do say that, but not in the law itself, because they're following what they call a technology-neutral approach. However, there is legal certainty that you can use a public blockchain to operate a crypto securities register. Right, and looking into this, if you are a financial services institution that operates a crypto securities register, which is essentially operated on a public blockchain, does that mean you need this license because you operate a public blockchain? This kind of sounds like a contradiction in itself, because the point of a public blockchain is that it does not need a single operator, and usually it does not have a single operator. But indeed, this is what the legislator has intended to do, because there was a big policy discussion whether it should be allowed at all to have a public blockchain as a securities register. And you could say the compromise that was found is that the entity that operates the register is liable for the proper operation. So it will be liable for damages if the confidentiality, integrity, and authenticity of the data are compromised, right? So this is something that we need to keep in mind here. It is a public blockchain which would not need an operator, but for legal reasons, there has to be someone who you can sue for damages afterwards if something goes wrong. And this is why, if you are that entity who is responsible for the operation of the register, you need the license as a financial services institution. Now again, this is only one building block in when you're considering your business model and what elements you have in there. As has already been mentioned, it's not allowed if you are a crypto securities registrar to also provide brokerage or to also provide custody. So these are different kinds of financial services licenses. Investment brokerage, Anlagevermittlung, which is essentially you receive orders, you receive subscriptions and forward them. You have the payment processing, Zahlungsdienste under CAG. If you want to touch the actual money, this is also something that you are not allowed to do as a crypto securities registrar in itself. Then you have e-money business, which is also a different kind of regulated activity. If you want to put cash on ledger, for example. And then we have the custody issue. As you're probably aware, there are different kinds of regulated activities as Kryptoverwahrgeschäft, crypto custody business, and general custody business, the Depotgeschäft, which is a banking business. So you need an even, you could say, bigger license in order to do that. So if you want to refrain your activities to what is allowed as a crypto securities registrar, there are certain limitations. You're not allowed to store keys, at least not in a form that allows you access to the actual assets that are on the register. You're not allowed to have power of disposal over securities, because this would constitute custody. However, this is also not quite clear in the law, because as we will see later, it is necessary in order to perform certain functions as a crypto securities registrar to have power of disposal over securities, right? But there is a clarification in the law. If you only keep the register as such, this shall not constitute custody within the meaning of the Custody Act, and at the same time, this does not mean you need a license for crypto custody business or custody business at the same time. And then I think what's also important in practice, you're not allowed to manage securities. That means you're not allowed to act on behalf of others in relation to the rights that are in the securities, because this would also constitute custody business. Another important point. Just acting as a securities registrar does not mean you're allowed to operate a secondary market. And I think many of you are aware of this issue, because it's very easy to become a central securities depository within the meaning of the law if you operate a blockchain for securities, right? So they are also, depending on the kind of secondary market that you want to implement, these activities are either investment brokerage or a multilateral trading facility or a central securities depository. In this regard, watch out for the upcoming EU pilot regime for market infrastructures based on distributed ledger technology. Many of you might have heard of that already as the DLT MTF regime. And there's actually a new draft of that, which has gone through the trilogue and now has been on the first reading of the European Parliament just end of March. And you can look into this. Now we have 3 different regulatory statuses, the DLT MTF, the DLT settlement system, and the DLT trading and settlement system. And these are not organized as specific licenses, but they are organized as exemptions from existing regulation. Because it's a pilot regime, it's limited in scope and size for a 3-year testing period. And yeah, it's expected to enter into force in 2020 already. So there's also a transition period if you have already commenced operations as a crypto securities registrar before December last year, and you've notified that to the supervisor ahead, and now you're going to submit a complete application for permission. Then you have a provisional permission to operate this crypto securities register. So some of the players are in this status at the moment and are just preparing the applications in order to file them with BaFin before June. Right, so what are general requirements for financial services institutions that you have to follow because you are, as a crypto services registrar, a financial services institution under the German Banking Act? Well, first there's this initial capital requirement of 150,000 euros. Then you need qualified managing directors who are not only professionally qualified but also reliable and must be able to contribute a sufficient amount of time. Now, what's a sufficient qualification? Usually, the law says it shall be assumed if you have 3 years of experience in managerial activity at an institution of comparable size and type of business. Well, obviously, this does not give much guidance here because there have not been any institutions of comparable business so far. So, if you plan on obtaining such a license, this should be something that you should discuss with BaFin at an early stage because judging from my experience, this is something that could become problematic. It's usually one of the first things that you clarify with BaFin. Then you have ownership control proceedings, like for any financial services institution. You need to provide BaFin with a business plan, including organizational charts and planned operations and planned balance sheets and profit and loss accounts. And then you have a lot of organizational requirements that you need to meet. And you need to have a regime in place of that. It's that you also need to file with BaFin for the review, including such things following from general regulation, risk, BAIT, data management, as it says there, internal audit, risk management. Outsourcing might be an interesting point here because you usually have various players working together here. The AML compliance and data protection compliance is also an interesting point because, as you're probably aware of, GDPR is not really designed to be applicable to decentral infrastructures. You may be required to file draft customer contracts with BaFin, and then after that, of course, you need to provide annual accounts, annual audit requirement, and reporting requirements. Now, what new specific requirements have been introduced by the Ewpg for crypto securities registrars? Well, first we have a number of general requirements that the register has to meet. These are related to the contents of the register, the roles and the rights of the registrar and participants, confidentiality, obviously, also the cryptographic processes and security. These need to be designed in a specific way as prescribed by the law. And keep in mind, the regulation, the ordinance, the Ewpg, so far is only in draft format, right? So we need to follow the legislative procedure and see what happens next, because this determines the details of the actual operations of the register. Then the register has to follow the time sequence. It must be state-of-the-art IT. There are specific industry standards in the law. You need a testing regime, and you need some form of ongoing transparency. Now, how does a security on the register come into being? You have two processes. The first is the publication, the Niederlegung of the terms, which is a regulated process, and the terms need to be available on the internet. There's a process for amendments to the terms, and then to create an actual security, you need the registration of the security, which has to reference to the terms. And this also has to be published in the Federal Gazette. Then we have a regime for the participation in the register and the transfer of securities. We have a definition of the participants. Participants are the issuers, the security holder, and the holders of certain rights that are recorded on the register. However, there are also other people who have an interest and a right to look into the register. Changes to the contents of the register, like transferring a security, can only be made on the basis of an instruction. And there are different kinds of instructions to the registrar via different, you could say, channels that have different requirements. So you need to implement the proper processes for that. And depending on the process, you also need to examine the authorization of the one who's giving the instruction to check its identity, you need to follow the priority principle of disposition, or the register has to be designed in a way that it follows the priority principle, which is also important with block time, things like that. And as the registrar, you have a duty to reverse incorrect changes if they have taken place. And then you also have the process of insight to the register, access to the register, Einsichtnahme, and excerpts, Registerauszüge. Now, if you are a participant to the register, then you need to have real-time access. So you can always check like the balances of the securities. But then again, the registrar has to provide access to anyone who demonstrates a legitimate interest. And again, under certain conditions, he has to identify who that is and assess this legitimate interest. And also there has to be a protocol of all those who have taken access to the register. And this has to be provided to the participants. And then the excerpts, they need to be given to security holders, depending if they are consumers or not, regular and on on-demand basis, and event-related. Okay, great, thanks. That's it. Thanks for your attention.